Welcome and thank you for joining Seyfarth webinar 2022 California Employment Legislative Update. All participants are in listen-only mode. You're encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE Credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE Credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Christina Lonnie. Christina, you may begin.
Great, thank you, Christian. Hi, everyone. Welcome to our 2022 California Legislative Update. We have a lot to cover for you today, as every year we do, but a couple of pretty meaty bills that will soon be effective as laws or already are effective as laws. So as you see our legal disclaimer up here, as you know we're required to do, we are providing you with information, not legal advice. And we will dig into what that information is in just a minute. Your presenters today, I'm Christina Lonnie, based in Sacramento. I'm our California Labor and Employment Legislative Team lead. With me are Kobe Turner, Sharday Scahan, and Kathy Feldman, all of us attorneys and counselors in our counseling group here at Seyfarth in California. So without any further ado, we're going to dive right into the first of the bills that, as California employers, you all need to be getting ready to comply with come either right now or January 1st, 2023.
Thanks, Christina. So for many of you, you were probably rapturously awaiting the end of September when the COVID paid sick leave bill was supposed to expire. Well, spoiler alert, at the last minute, can we move to the next slide, please? At the last minute, the governor signed an extension of the COVID supplemental paid sick leave bill, which is effective immediately. So rather than expiring on September 30th, it has been extended to December 31st of this year. It's not a bank of new leave, so it's only the existing leave that you should already have on the books, which is 40 for a number of qualifying reasons like vaccinations, getting tested, school closures, and that sort of thing, and another bank of 40 if your employee or someone in their family tests positive. So the reasons for taking it are the same. They don't get any additional leave, so if they've already exhausted it, they're out of luck. But if they haven't used it yet, they now have until the end of the year to use their existing supplemental paid sick leave. There are a few changes in this bill, which are some welcome additions for employers. The main one being, which I know many of you have been dealing with, which is if somebody tests positive, you can have them test on day 5 or later to see if they test negative, and they can come back to work so long as they are wearing a well-fitting face covering. What many of you may have been dealing with is somebody that tested positive still on day 5 and they had to stay out. Well, now you can require a second test at 24 hours or later after that first test if they still test positive. So you can require them to test on day 6, 7, 8, 9, 10, and then hopefully return them a little bit earlier to work if they start to test negative, which you weren't explicitly allowed to do under the prior version of the legislation. If someone refuses to take the return to work test, you can refuse to continue to provide them with supplemental paid sick leave. So I know that that's been a big sore spot for employers where you felt like people were sort of milking it to take their full 10 days out. Now you can require the second test or cut off the Spsl if they don't test. Additionally, moving on to the next bill, we have the extension and changing of the existing COVID notification requirements. This is something that it's required both by Cal OSHA and previously it was AB 685, which some of you may remember was a bit of a doozy passed in 2020 when the pandemic first started. So under AB 685, as many of you are aware, if you had anyone that tested positive that was in the workplace during their infectious period, you had to provide a generalized notice to individuals who may have been exposed in the workplace as well as close contacts of the individual in the workplace. So this is going to extend. So again, AB 685 was supposed to expire this year. This is going to extend those notification requirements into the January of 2024, so another year. And also part of AB 685 was that it was giving Cal OSHA some extended abilities to shut down a work site based on an imminent risk of a COVID-19 infection. Cal OSHA's always had the ability to shut down a work site for serious dangers, but the COVID-19 shutdown ability was an expansion of that. This is extending that expansion. As far as the notification requirements go, though, this bill may provide some respite for employers who, particularly those of you with large workplaces where you feel like you've been sending out these individual notification things weekly to people. This provides the ability to choose an alternative option, which would be posting a notice of COVID-19 exposure in a prominent place, much like you do with your minimum wage posters. That would still contain the same information that you have in your individual notice for the most part, and you still have to post it within 1 business day, but it provides you with an alternative to passing out a bunch of individual notices to people. You would need to keep a log of all dates that the notices were posted for purposes of examination by the Labor Commissioner if they wanted to, and you have to keep the posting up for 15 days. So if you don't like the individual notices, they're too much of a hassle, this will now be an option under this new bill starting the first of the year. But there's a big caveat here, which is that the current version of the Cal OSHA emergency temporary standard requires written notice still. So at least until we figure out what Cal OSHA is going to do with the ETS at the end of the year, you are still required to do the written notice by Cal OSHA, even though this legislation gives you the pass with a posting. Cal OSHA doesn't yet. For those of you that are following it closely, you likely know that Cal OSHA has proposed an extension of the COVID-19 prevention standard, which they are considering at their December meeting. And they have removed the explicit requirement for written notice. So ostensibly it will mesh with this legislation if the new proposed temporary standard, or not temporary, the new proposed COVID standard is passed in December. It should mesh with this legislation, but we are waiting to see what will happen with that come the December meeting. And then moving on to additional forms of leave that have passed in this version or in this legislative session. A big one for employers and employees is the passage of a bereavement leave statute, AB 1949. So what this does is it amends the California Family Rights Act, or the CFRA, to provide for up to 5 days of bereavement leave for employees who have been working for you for 30 or more days. They're allowed to take this bereavement leave upon the death of a family member, including a spouse or child, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law, very similar to what they are currently now allowed to do for Cfra leave. The leave has to be completed within 3 months of the death of the family member, but it doesn't need to be consecutive. So if they want to take 1 or 2 days off when the person first passes away, and then some additional days later on for the funeral or dealing with affairs related to the death of the family member, they can do that, and it doesn't have to be consecutive. The employer is not allowed to retaliate against an employee for requesting bereavement leave, nor is an employer allowed to deny the request for leave. Those are both explicitly in the statute. If an employer doesn't have a paid bereavement policy, the leave may be unpaid, and the employee is explicitly entitled to use accrued vacation, personal leave, or other available sick leave or time off that they have on the books already. An employer is allowed to request reasonable documentation, and that would include things like an obituary or some sort of public reference to the individual's death, a death certificate. The law is very vague on what kind of documentation you are allowed to require, and it, in fact, refers to or other types of verification. So we would just urge you to, exercise caution if an employee tells you that they've had a family member die and they present you with something that looks at least remotely credible. Consult with your counselors if you have reason to believe that it's something suspicious. But other than that, it's a pretty broad allowance.
And this is one that had been many years in the making. Previous attempts to get bereavement leave codified were rejected as, a lot of companies already provide bereavement leave, so there's no need to put it actually as a legal requirement, but it finally made it through this year.
Yes. And we've had a number of questions coming up about whether or not the bereavement leave will apply to the designated person, which I'm going to go over on the next slide under Cfra. And the current version of the statute explicitly only refers to these particular family members and does not incorporate designated person. However, you know, the legislature, many of us think this is probably a drafting error. The bill's kind of crossed paths, but at least for now, the way it's currently worded, it does not encompass the designated person. That's not to say they won't change their mind and realize in 6 months that they made a mistake, but for now, it doesn't. And so, which is a natural transition to the question about the changes to Cfra's definition of family members and designated persons. If we can move on to the next slide, please. So there has been some amendments to the CFRA and California's paid sick leave, and this is to include a designated person for who an employee can take leave or days off. So either for them to take protected California Family Rights Act leave for a seriously ill family member or designated person now, or they can use their own individual sick leave to care for someone who's ill, including a designated person. To keep things nice and complicated, the designated person under the CFRA and the designated person under the paid sick leave law are defined differently. So under the CFRA, a designated person is defined to be an individual who's related by blood or whose association with the employee is equivalent of a family relationship. The discussion in the bill of this law was explicitly to recognize, you know, sort of the modern family dynamic in California, particularly in minority communities living in multi-generational households or in non-traditional family units where it may be people that are not technically blood related, but are like, you know, very close friends that are being raised in the same household. And also a big push was from the LGBTQ community and their chosen families. And so the idea being that although these are not traditional family relationships under the, you know, the sort of traditional nuclear standard, that the nuclear family standard that these laws were designed under, that in California, they're recognizing a much broader understanding of the nature of families. And so that's what the impetus was for the change in this law. Under the paid sick leave law, however, they just basically, it's any person that they want to designate. So ostensibly could be a roommate or whatever. It gives no qualification there for the paid sick leave. It's much broader. For both the CFRA protected leave and the paid sick leave, the employee is allowed to designate the person at the time of requesting or taking the leave. So they don't have to tell you at the first of the year that like Joe is going to be my designated person for the next 12 months. They can wait until they need to take the leave to tell you, but that you can limit them to one designated person every 12-month period. So they can't continuously rotate who the person might be that would be covered. And then, excuse me, under the CFRA, employers may require the employee to substitute accrued vacation leave or PTO during the protected leave or any other form of paid time off that they may have negotiated with the employer. And with that, we will move on to the pay transparency legislation.
So there have been a lot of changes in the pay transparency state nationwide, but especially in California. SB 1162 was signed by Governor Newsom, and that's going to make significant changes to employers' pay data reporting and pay scale disclosure requirements. There's kind of two parts to SB 1162. So first, we're going to discuss the pay data reporting. A lot of you were probably previously required to comply with the pay data reporting requirements passed in 2020 because it applied to private employers with 100 or more employees who were required to submit an EEO-1 report. SB 1162 does away with the requirement that you also be required to submit an EEO-1 report. So now if you have 100 or more employees nationwide, you will be required to submit the pay data report as long as at least one of your employees is in California. You're only required to report on the California employees, but to determine whether or not you meet the threshold for reporting, that is based on your total employee count throughout the United States. So, or if you're international too, your global employee count. So that's something to consider, that if you weren't required to report before, you might be required to report now. So definitely double check that. There's also a new deadline for the pay data report. It was previously at the end of March, March 31st, and now it's been pushed back a little bit to the second Wednesday of May. So the first report in 2023 will be due on May 10th instead of March 31st. One huge aspect that has been amended for this pay data report is that you will now be required to report a mean and median hourly rate for each combination of race, ethnicity, and sex within each job category. Part of the reason this change was being made is because they are trying to get a feel for whether there is equal access to opportunity as well as equal pay taking place. So that's why they're now including the mean and median hourly rates. So that's going to have to be calculated based upon the numbers that you have for each combination of race, ethnicity, and sex within each job category. So that is a new aspect that you're going to be adding this year from your previous reports that you might have been submitting. Another big change to the pay data reporting is that you are no longer required to file a consolidated report if you're a multi-establishment employer. You still need to file a report for each establishment, but you no longer have to also file that consolidated report for all of the establishments that you're reporting on. There are also some new penalties associated with the reporting: $100 per employee for an initial failure to file and $200 per employee for subsequent failures to file. So the penalties for failing to report can get pretty substantial really quickly depending on the size of your workforce. And this was new because previously there wasn't a lot of enforcement availability for the CRD to try to get people to comply, because there weren't a lot of penalties associated with failing to comply. So now these penalties have been added to the reports, and they're going to be on a per employee basis. On the next slide, we're going to cover another significant aspect of this SB 1162 requirements, and that's going to be the contractor pay data report. This is something that we've been getting a ton of questions on already, because this is a really big new piece of SB 1162, and that's the requirement to file a pay data report on any contractors that you are hiring. That's going to be 100 or more employees hired through labor contractors. Now, the language is really important because 100 or more employees hired through labor contractors is the actual language that the text of the law includes. But as you might realize, most employers are not hiring employees through labor contractors. That is, most employers are not putting labor contractors on their payroll. And the law specifically defines employees as individuals on an employer's payroll, including part-time individuals. So there's a bit of a disconnect here between who is going to be reported and then who they actually aren't reported. The goal of the law and the intention is to get a report on all of the various labor contractors that might be working in California. But the way it's been defined as 100 or more employees hired through labor contractors doesn't necessarily accomplish that mission. So if you think that this aspect might be applicable to you, this is definitely something to discuss with your legal counsel about how to handle this contractor pay data report. Another aspect of the contractor report is that the labor contractors are required to provide the necessary information to the client employers so those client employers can prepare the reports. But there's no specificity as to what information specifically is going to need to be provided to the client employers, or whether the information even needs to be tracked by the labor contractors if they have a current obligation to track the type of information. And then finally, the law doesn't actually explicitly define what is going to be included content-wise in the contractor pay data report. We assume that they're going to be looking for the same type of information that you get for the employee pay data report, but the law doesn't actually say specifically what is going to be included in that contractor pay data report, nor does it clarify other aspects such as, are we using the bill rate or pay rate, for example, for the labor contractors. So we anticipate we're going to get some FAQs clarifying some aspects of this contractor pay data report moving forward. The other aspect of the amendments to the pay scale and the pay data reporting and pay scale transparency is, on the next slide, we'll cover the pay scale disclosure requirements. So this is under a separate section than the pay data reports. This is under the labor code, and employers currently are required to provide pay scale information to applicants upon reasonable request. That requirement remains in the law even with the amendments. The new pieces are that now employees, current employees, will be entitled to request the pay scale for the position that they currently hold. That is one of the new aspects for this pay scale disclosure requirement. Another significant change is that employers with 15 or more employees are going to be required to include the pay scales in job postings. There's no explanation right now as to whether that's going to be 15 employees or more in California or 15 employees or more total throughout the company. So hopefully we'll get some guidance on that, but as of right now, it doesn't specify one way or the other whether it's only based on your California employees or if you have 15 or more employees total. The pay scale that you're disclosing will be based upon the hourly rate or the salary, and it's just supposed to be the range that you reasonably expect to pay for the position. That's what you're including in the job posting. There's no further guidance or explanation as to including bonuses or anything like that. So it just says that you're posting the pay scale that you reasonably expect to pay for the position. Since it does use the term pay scale and it does expect you to post a range, that means you aren't going to be posting just the lowest end of the range and say $15 per hour and up, for example, because that doesn't have an end rate of the range. That would likely not comply with this requirement. So to the extent you have a range that will be paid for a position, you have to post the low end and the high end of the expected range that you're going to pay. You can, of course, pay more than the top of the range as well. This just needs to be what you reasonably expect to pay for a position. You also have to provide pay scale information to any third parties that will post on your behalf. So if you have someone else handling your job postings, they still will be required to include your pay range information in the job posting that they are posting on your behalf. One thing that is important to note about California's new law is that unlike other states where, for example, Colorado, where they have that promotional opportunity requirement and you have to publish or make known that there's a job opening available, you don't have to do that in California. That was in a previous version of the bill, but it was removed in one of the amendments. So there's no requirement under the labor code now that you post every single job that's available or make it known to potential candidates or employees. But if you do post and you meet that 15 or more employee threshold, then you will be required to include the pay scale in your job postings. Another aspect that we don't have clarification on, but we hope to in the future, is how this applies to remote employees. As of right now, there's nothing explicitly addressing remote employees. Other statutes we've seen across the country and other jurisdictions do, but California's doesn't. If California follows the same interpretation that we've seen elsewhere, then you will be required to report the pay scale for any positions that might be remote but able to be performed in California. Again, there's nothing explicitly saying that yet, but if California follows the lead of other jurisdictions, that is the approach that they're going to take for remote jobs if it can be performed in California. And then finally, on the last slide for SB 1162, we have a record retention requirement. This is going to require you to maintain job titles and wage rate histories for the duration of an employee's employment plus 3 years after the end of their employment. And these records are going to be open for inspection by the labor commissioner, so you'll want to make sure that you maintain these records as required. There can be significant fines for failure to maintain the records, ranging anywhere from $100 per violation up to $10,000 per violation. We have no guidance as to how they're going to determine what fine would be assessed for your violation, but as you can see, it's a really, really broad range of potential fines. You can avoid a fine for the first violation of your failure to post the salary scale in your job postings as long as you are able to show that all of your open job postings have been updated to include the pay scale for the positions for which you are posting. And next, Kathy is going to discuss some of the other things in store for employers.
All right, so we're going to pivot from talking about pay reporting to talking about POT. If you can go to the next slide, we have AB 2188, and what this law does is it prohibits employment discrimination based on employees and applicants off the job cannabis use. The law essentially makes it unlawful for California employers to rely on positive cannabis drug test results if the test screened for non-psychoactive cannabis metabolites. And that is a big way of just saying that most of the currently available workplace drug tests are not going to be permissible once this law goes into effect on January 1st, 2024. So while you have some runway before the shift commences, we still recommend developing a plan, modifying policies and practices now so you can mitigate the risk of this new category of claims. And we've already seen that there are courts that are not friendly to discrimination lawsuits based on off-duty cannabis use, even without this law being on the books, if there isn't any indication that a person was impaired at work. Given that employers don't currently have access to scientifically reliable drug tests that prove impairments, we're recommending that you implement a robust, defensible, and reasonable suspicion testing process that would include training for managers and teaching them how to recognize and document the signs of impairment. There are some things that you can still do. Like I said, this obviously doesn't impact your ability to maintain a drug-free workplace, and your obligations and rights under federal law regulations are not preempted. And on the next slide, you'll see there are some industries and employees that are exempt from this law, including employees in the building and construction trades. However, the law doesn't specifically define what the building and construction trades entails. There might be some ambiguities around that. Other people that are not impacted by this would be applicants and employees to positions that require federal government background investigation or security clearance, or applicants and employees required to be tested for controlled substances under applicable laws, or as a condition for receipt of federal funding or benefits or contracts. So that's a fun one. Next, we're going to move on to the emergency conditions provision. And this law is going to prohibit employers in the event of an emergency from taking or threatening adverse action against an employee who either refuses to report to work or leaves a workplace because they feel unsafe, and also who have also been preventing employees from accessing their mobile devices for use for an emergency. And how the law defines an emergency condition is pretty significant here. The motivation behind this law was a lot of the natural disasters, fires, mudslides, and the like that we've seen, as well as active shooter situations. Importantly, the law does not extend these provisions to healthcare emergencies. This is specifically intended for conditions of disaster, extreme peril that are caused by natural forces or a criminal act, or an order to evacuate a workplace, a worker's home, the school of a worker's child, similarly due to a natural disaster or a criminal act. And we have seen some other laws that kind of fill that gap here for healthcare emergencies, particularly in jurisdictions like San Francisco, where we've got the public health emergency leave law already in place. So there are other jurisdictions that are starting to anticipate some additional provisions around that, but this is not one of them. We are anticipating that there might be some issues for employees who want to carry a phone when they're expecting to be in an evacuation zone for a fire or something like that, but they're not yet in an evacuation zone. So there are some kind of, again, areas of ambiguity here that aren't addressed by the law. And if we can just move to the next slide. Yes, so as I was saying, this doesn't apply to a health pandemic specifically. And although a lot of these emergency situations, as you would anticipate, they're emergencies, there's not a lot of opportunity for advance notice. But when feasible, employees are required to provide some advance notice of the conditions. And we could see that again arising if someone's moving from a almost evacuation zone to, okay, now I am in an evacuation zone. There might be some opportunities for advance notice there. And in the law, it does provide that there could be that a violation of these provisions could subject an employer to a private lawsuit under PAGA, and penalties under PAGA, but it also allows for an opportunity to cure violations. And next, we're going to be talking about some industry-specific legislation. The first industry that we're going to address is the fast food industry with the Fast Recovery Act. And what this act does is it is establishing a fast food, say that 5 times fast, fast food sector council that's going to be tasked with creating a workers' bill of rights and establishing minimum standards for fast food restaurant employees. And those standards are going to include things such as wages, working hours, minimum wage, etc. And they're intended to ensure and maintain employees' health, safety, and welfare, and supply them with the proper cost of living. This law is going to take effect on January 1st, 2023, and it's going to be operative for a 6-year period until January 1st, 2029. And during that period, the council will be required to conduct a full review of the standards that they've put in place once every 3 years. So after the first 3 years, they can modify, amend, repeal any of the standards they've set in place, which will likely create some operational and administrative costs and hurdles for employers, just given the speed at which there might be some changes to processes that you've recently implemented. The standards that the council sets cannot supersede standards that are covered by a valid CBA, provided that the agreement includes equivalent or greater protections than the council standards and doesn't waive any occupational health and safety protections. There are some narrow exemptions for restaurants such as bakeries that are solely producing on premises and selling bread as a standalone menu item, and any type of fast food establishment and a grocery store, if the grocery store is the one that's employing the individuals that are working in the restaurant. Moving next to SB 1334. This is a law regarding public sector healthcare employee meal and rest periods. And the purpose of this law was essentially to create equity between public and private healthcare employees and their entitlement to meal and rest breaks. So public sector healthcare employees now, like private healthcare employees, will be entitled to meal and rest breaks, including any premium payments for missed or non-compliant breaks. And again, like we've seen in other provisions, this is not going to apply to employees covered by a valid CBA, assuming that that CBA provides for meal and rest periods and premium payments.
2 big picture notes on this bill and the prior bill. So the FAST Act, yes, applies to, fast food industry, but it has gotten a lot of press and a lot of concern from a lot of employers and really the businesses in whatever industry, because it is kind of a groundbreaking law and attempt to move things in a different direction. And the concern is, might that be applied or extended in some way in future years to other industries? So we're keeping our eye on that. And then with this bill, we typically don't do a whole lot of industry specific, but we do it where we quite often get questions from clients saying, I heard there was a new meal and rest period law. What do we do? So we're highlighting this obviously for our healthcare clients, but also for all of our other clients to know that this change in meal and rest period law is to a very certain group of employees and employers.
Thank you, Christina. And moving to the next slide, we're going to be discussing AB 676, another industry-specific provision that prohibits a franchisor from failing or refusing to grant a franchise or grant financial assistance to a current franchisee or a prospective franchisee based on characteristics that would be protected by the Unrest Civil Rights Act, or on the geographic area where the franchise is located, if any characteristics or the composition of that neighborhood is also protected by the UNRRA Act. And so again, another pretty narrow application. And then moving to our next slide, which discusses AB 2183, the Agricultural Labor Relations Act. The purpose behind this one was that it was intended to make union elections easier as well as more secretive. And it now allows individuals to vote in private for labor unions rather than at a polling place. And this one was signed relatively late. It was a little uncertain whether Governor Newsom was actually going to sign it. As you may know, last year he vetoed a similar measure that had directed the LWDA to work with the Agricultural Labor Relations Board to correct certain procedural irregularities. And this year, he really only ultimately signed this bill because of pressure from President Biden, who is obviously a very union-friendly president. So it's interesting to see where his leanings are going this year regarding union activity. Moving next to AB 1601, this impacts call centers and call center employees. It's going to be prohibiting a call center employer from ordering a relocation to a foreign country of either a call center or one or more facilities or operating units within a call center that comprises at least 30% of the call center or operating units total volume from the prior rolling 12-month period. And the relocation has to be done pursuant to a 60-day notice. And this law went through a pretty extensive revision. It was initially supposed to be a 120-day notice period, so it was significantly shortened to 60 days. And when providing that notice of the relocation, employers are only required to do a single notice, and it must include at the top that it is for relocation of a call center. The EDD will then be compiling and publishing a list of employers that are operating a call center that provides the notice. And the EDD is also being tasked with providing workforce services to call center employers and their employees who are laid off as a result of the relocation. There's also certain enforcement remedies in place in this law for failure to comply with the notice requirements, including making it that these call center employers would be ineligible to be awarded or have renewed state grants or state guaranteed loans for a 5-year period, or ineligible to claim a tax credit for 5 years beginning from the date that the list is published. So some interesting developments there. And I'm going to turn it over to Christina now to talk about some other legislation.
Okay, so I'm going to do just a little bit of cleanup here. Really, Sade, Kathy, and Kobe covered all of the really significant ones and the really significant compliance challenges that employers are mostly going to need to prepare for. Note that where we did not note the effective date of a bill or a new law, it's January 1st, 2023. Where there is an effective date that is either delayed or that is sooner than that, we would have otherwise indicated. And for the many folks who like to, read the written product after the fact as well, yes, you will be getting these slides after the fact. So don't worry, despite the fact that we're going through this pretty quickly. So the first piece of the kind of clean up all of the other legislation that you need to know about going into 2023 is one that you wouldn't typically think about as much in the employment context. It has to do with sexual assault and the statute of limitations. This sounds much more procedural and less, what does this mean for me as an employer? Well, this bill does a couple of things, and this bill is actually dubbed the Sexual Abuse and Cover-Up Accountability Act. So while it does a couple of different things within this bill, as specifically relevant to companies or to employers, this bill will allow claims for damages from sexual assault that are otherwise barred by the applicable statute of limitations to be filed between January 1st and December 31st, 2023, where the plaintiff alleges that the plaintiff was sexually assaulted, that one or more legal entities are responsible for damages from that sexual assault, and that the entity or persons within the entity attempted to cover up or prevent, reporting of the sexual assault. And it also revives claims for related claims like sexual harassment or wrongful termination. So that is one that, for at least the next year, things that might have otherwise been time barred. I mean, with this heightened, pleading requirement that they have to allege there was some sort of attempt to cover up the sexual assault, will be able to be filed again within the next year. On the next bill of interest to employers, it's a bit outside the normal box. We're talking about AB 1632. And this one has to do not necessarily with employment, but it does affect employees because here, this bill requires businesses that are open to the general public for the sale of goods, retailers, for example, and have a toilet facility for employees. Those businesses will be required January 1st, 2023 and onward to allow any individual who is lawfully on the premises of the business to use the toilet facility during normal business hours if certain conditions set forth in the new law are met. Now, the person can produce and the company can require a signed statement from a doctor, nurse practitioner, or physician assistant that states that the person has, one of the conditions that would give rise to the need to use the restroom, whether, a business is going to want to do that and to what extent, is a compliance and policy and training issue. The penalties, however, are not real severe. It's $100 per violation, but really this law is trying to encourage the opening of restrooms that are already on the premises, but otherwise not made available to the public for folks who need to use those restrooms. And the next bill, AB 1788, again, somewhat industry specific, but because this is not a pure employment bill, we have it down in other legislation, but for our hospitality clients, we thought that we wanted to flag it for you. This bill would subject hotels, which are defined, as you can see here in the slide, to civil penalties if a supervisory employee of the hotel knew of or acted with reckless disregard of sex trafficking activity within the hotel and failed to inform law enforcement, the National Human Trafficking Hotline, or another appropriate victim service organization, or if any employee of the hotel was acting within the scope of employment and knowingly benefited from participating in a venture that the employee knew or acted in reckless disregard of sex trafficking activity within the hotel. So just additional requirements put upon hotels to ensure that sex trafficking is not happening. Okay, what you've all been waiting for, the CLE code. You ready for it? You got your pens, pencils, typewriters ready. It is SS 4733. Saying that again, that's SS as in Seyfarth Shaw 4733. SS 4733. Okay, CLE code red. we are going to highlight just a couple of bills that didn't make the cut this year. We usually do this because, again, we get a lot of questions from our clients. Hey, what about this new requirement that there's, now a flexible work week? And we say, yeah, that one didn't make it through the process. So there is one on the flexible work week. There are most years, and it hasn't made it through yet. But before that, we're going to talk about, as our first bill, one that didn't seem really controversial, but the governor vetoed it nonetheless. SB 1262. This bill was inspired by the California Court of Appeals decision in the case called All of Us or None of Us versus Hamrick. And in that case, the court held that an individual's date of birth and driver's license number could not be used as data identifying a criminal defendant in public records. So what this resulted in was courts around the state redacting birth dates and driver's license numbers from their indexes, which made routine background checks difficult. So this bill attempted to change the court rules to allow publicly accessible electronic indexes of defendants in criminal cases so that searching and filtering of results based on a defendant's driver's license number and date of birth could happen. The governor vetoed this bill essentially because while it would provide for a more convenient process for companies to conduct commercial background checks, it would also allow any member of the public to easily access individuals' sensitive personal information online. So that's what the governor thought. This bill met its fate. Unfortunately, things are still going to be a little more difficult for background checks to be run until probably next year when the legislature tries it again in some different form. The next bill is an interesting one, AB 1102, because here, this bill had some amendments that did not even actually go through that would have extended or made permanent some exemptions under the California Consumer Privacy Act, which will, be the California Privacy Rights Act, that would be applicable to personal information collected in human resources and business-to-business contexts. Those of you who are very proactive are already well under your way to get ready for the changes to the California Privacy Rights Act that will apply to employment now come January 1st, 2023. This bill would have helped employers in this way. The amendments didn't go through, so you've got to keep on keeping on with getting ready for those changes. We have put out various blogs on what employers need to be doing to get ready for this. We're also going to have another webinar on November 3rd that will give you tips on how to get ready in the last couple months before you need to put these new compliance measures with the CPRA as applied to employees into place and implementation on January 1st, 2023. As you can see, in a nutshell, what this does without the exemption that this bill almost would have helped with is starting January 1st, covered employees will have increased rights with respect to their personal data collection, correction, deletion, portability, and disclosure, and employers will have a whole lot of obligations and things to get in place to make sure that those rights are protected and that the company stays out of trouble. On the next slide, we just gave you two little teasers about bills that did not make the cut and that might be back again next year. One of the, oh my gosh, I can't believe they're doing this, bills that was floated at the beginning of session that didn't even make the cut past one of the earliest deadlines in the legislative session was AB 2932, the 32-hour work week. And what that would have done was instead of, our standard 40-hour work week, it would have required time and a half overtime be paid for over 32 hours in a week. And it would have also prohibited an employer from reducing an employee's overall previous compensation to make up for the fact that they're working a reduced hourly work week requirement. That one didn't make it through, but they'll probably try again next year. Also, the Workplace Flexibility Act of 2022. The legislature was not flexible. It maintained its position that it is maintained on this topic every year, again this year, which is, even though people say that workers might want to be able to request an employee selected flexible work schedule, we're not going to legislate it yet again this year, so they'll have to wait yet again. So there were other bills that failed to make the cut. We summarized them in our earlier in the year California Labor and Employment Legislative blog. So if you're curious what else might be back again next year, feel free to go to those blogs. Our next slide here has links to where you can find that resource and other resources. As I noted, you will get these slides after the fact as well as a recording, so you can click through to the links there. Please tune in to our webinar on November 3rd if you want to know more about the CCPA, CPRA changes. But we were so quick today in making sure that we covered everything for you that we have time to address some of the questions that came on through. So Kobe, why don't we start with what were some of the top questions that you saw on the leave bills that you think folks might want answered?
Yes, thank you. That was exactly what I was going to do because I clearly had a few gaps in going over these. I got a lot of the same questions from a number of you. So with respect to the bereavement leave, one of the questions that I had was that if you currently have a policy that provides for 3 days, which seems to be sort of industry standard for a lot of private companies, do you have to now, and you you provide 3 days of paid leave, do you now have to provide 5 days of paid leave? And the answer to that is no. You can have a combination of paid and unpaid leave. So you can just add in an additional 2 days of unpaid leave. So long as you offer 5 days total of leave, you can pay for none of it or some of it, but you don't have to you do not have to extend the paid portion of that leave. I also got a couple of questions about if your workplace is governed by a CBA and your CBA provides for some bereavement leave, how does that play into it? The statute for the bereavement leave says that you can be exempt if you're covered by a CBA that governs working conditions and wages if the CBA provides for at least as generous of bereavement leave as required by the statute. So that means that your CBA would need to provide for a minimum of 5 days of bereavement leave in order for you to take advantage of the CBA exemption. If it doesn't, then you will be subject to the terms of the statute, and the bereavement leave, you don't get to use the CBA exemption. Another question that I saw come up a number of times has to do with the COVID supplemental paid sick leave. There was a couple of questions there. Since this is not a new bank of leave, I saw some questions about, well, what if you were hired after October 1st, or you were hired right before, right at the end of September? Could you potentially still get the whole 80 hours? And the answer is yes. So all it does is change the expiration date of the statute, but the actual number of hours that people are entitled to remains the same. So even if they weren't hired until October 15th, ostensibly they could use a full 80 hours by the end of the year. In addition, I got a number of questions about could you discipline people for using the SPSL or for missing work once they have exhausted their SPSL banks. And the answer to that is no, for 2 reasons. One being that under the specific SPSL statute, you're not allowed to discipline people for or retaliate against them for using SPSL as authorized under the statute. If you have reason to suspect that they are lying, like they're foolish enough to be posting pictures of themselves on Facebook at Disneyland when they're supposed to have COVID, then we've got another story. But absent something like that, you're not allowed to discipline them for using the leave they're entitled to under the statute. And even once they have exhausted the SPSL, Cal OSHA, as part of the COVID protection standard, prohibits retaliation against employees for reporting COVID illness or symptoms. And so if they even if they've already used 80 hours of leave because they've gotten sick once and they've had a kid get sick once, and they get sick again and they can't come into work because of that, you're not allowed to retaliate against them based on the Cal OSHA standard. So it's not specific with relation to the SPSL law, but it is in the Cal OSHA standard nonetheless. Those were the biggest questions I saw. And I think maybe Sade, you had a lot of questions coming in about the pay transparency. You might be able to provide some elaboration on some of those hot topics.
Yeah, definitely. So one question that I saw come in a lot about the pay transparency law is whether or not you have to post a range in your posting. The text of the law says that you have to provide a pay scale of the range that you reasonably expect to pay. So if you only will pay $15 for a job and you wouldn't pay any more or any less, then you wouldn't post a range because you're not actually going to pay anything aside from $15. And you would just have to note that if you ever got questioned of why it's not a range, why it's a certain number, that you wouldn't pay anything aside from $15 for the position. There is risk for that because then if you decide that you do want to pay more for a role, then that would definitely open you up for legal challenges. So as far as posting the range is concerned, I'd really take a look at kind of what the salary and hourly rates are that you have for positions and whether or not the range that you have is accurate for the postings. That kind of leads me to another question that I got a lot, which was the fines. The $100 through $10,000 fines also applies for the job posting pay scale violations. So if you don't post a range in your job posting, you can open yourself up to the fines if you don't post the range that you reasonably expect that you will pay for the position. One of the questions that I saw come up a few times about the pay data reports is whether or not they're going to be made public. As of right now, they aren't going to be made public. That was something that they were trying to do in a previous version of SB 1162, but that requirement was removed in one of the amendments. So the pay data reports are not going to be made public, but the Civil Rights Department, formerly the DFEH, will publish aggregate data that you should not be able to associate with any specific company. And they already have made a publication before of the aggregate data. So you can go on the website and kind of get an idea of what it is that they're going to publish. But your specific individual reports for your company will not be published or made public, at least. Just the CRD will have access at this time.
I think we have a couple more minutes. And Kathy, there was a handful of questions that came in as well about the drug testing. I don't know if you've had the chance to answer those. I'm happy to jump in if not. You feel free to interrupt me. So some of the questions that have come in about the drug testing issue is whether or not the law prohibits employers from having THC in the drug panel. And it doesn't explicitly do that. It just says you can't take any employment actions based on that. So should you have it in the panel? Probably not, simply because if it comes back positive in the panel and they also test positive for heroin and meth, chances are you want to not employ them or you want to screen them from your employment pool because they've tested positive for some very heavy drugs. But then you've just given them a paper trail to a case that like maybe you also retaliated against them because of the THC. So if you can eliminate it from the drug panel, it's probably advisable to do that, but the law doesn't explicitly ban you from having THC in the panel. And Kathy, were there other questions that you saw coming up from your sections that we might be able to address here?
I think I've addressed all of the ones that were coming in. I know there was a question regarding the emergency conditions, and I kind of glossed over the actual definition of emergency conditions, so I can provide that now. It's defined as conditions of disaster or extreme peril to the safety of persons or property at the workplace caused by natural forces or criminal act, or in order to evacuate a workplace, a worker's home, or the school of a worker's child due to natural disaster or a criminal act. And there are some exempt employees from that bill, including first responders, disaster service workers, employees on military bases, and employees of residential care facilities, among others. So I apologize for skipping over that earlier. But I don't believe there were any other unanswered questions in my sections.
Awesome. Well, we should repeat for everyone that if you have questions that we did not answer, feel free to follow up with us or, with the Seyfarth attorney with whom you regularly speak. We obviously couldn't get to every single question. You all asked some great questions. But again, we will be distributing the materials after the webinar. And please check out our CalPEX blog. which
Christina,
has
can you
even
please
more
repeat the
information.
CLE code one more time? We had a couple
One more
people.
time.
Yeah.
Yes. The CLE code is, now you're going to make me like make up funny things for the SS. SS 4733. When I say this code too many times, I start saying SS like slippery slope.
Slope.
4733 or skinny snake. I don't know, but it's 2 S's and then 4733. So hopefully we can end this presentation on a light note. You do need to do some things to get ready for January 1st or the extension of the SPSL. So if you need help, reach out. Thanks all for tuning in.